Is not contemplated by the word distributed. His lordship did not express any final opinion on the meaning of word distributed in Article 39b. He observed, a nationalized property is vested in the state, through the state. The entire people collectively may be said to own property. It may be said that in this way the ownership of the nationalized property is distributed amongst the people represented by the state. Parnapi 936, 937, Constitution 20, 9th Amendment. The argument that Article 31b is inextricably connected with Article 31a, and accordingly any law which is included in the 9th Schedule SH would be connected with agrarian reforms has been rejected by this court. 37, 938, State of Bihar. Maharaja Dhiraja Sir Kameshwar Singh, 1922 SCR 889, Visheshwar Rao Ver, State of Madhya Pradesh 1921 SCR to enter. Danara 37, NNJC 1 Poiver, Assistant Collector Thana, 1965. 1 SCR 636, 648, referred to Chandrachud. The Constitution 24th, 25th, and 29th Amendment Acts are valid 1000. The Constitution 24th Am. And merely clarifies what is as true law. Article 368 before the 24th Amendment contained the power as as procedure for amendment of the Constitution. Article 13.2 took in only ordinary laws, not amendments to the Constitution affected under Article 368. The power of amendment of the Constitution conferred by the then Article 368 was wide and unfettered. It reached every part and provision of the Constitution. The decision in Goloknath that Parliament had no power to amend the Constitution so as to abrogate or take away fundamental rights is incorrect. There are no inherent Jamita tie-ins on the amending power, in the sense that the amending hotly lacks the power to make amendments so as to damage or destroy the essential featum or the fundamental principles of the Constitution, pp. 999, 1000. The whole matter before the court is truly sui GCNMS p. Foisemer. The leading majority judgment in Goloknath did not decide whether Article 368 itself could be amended so as to confer a power to amend every provision of the Constitution. The case was decided on the basis of the unamended Article 368. The question whether fundamental rights could be taken away by amending Article 368 was not before the court. The question whether in future Parliament could, by amending Article 368, assume the power to amend every part and provision of the Constitution, one not an issue before the court. The observation in the leading majority judgment, putting restraints on the future power of Parliament to take away fundamental rights, cannot therefore constitute the ratio of the majority judgment. The view taken by the majority of judges in Goloknath was that Article 368 PM prescribed not merely the procedure for amendment, but conferred the power to amend the Constitution, and the amending power could not be traced to the residuary entry 97 of List. Our Schedule 7 read with Articles 245, 246, and 248 of the Constitution appear. 960, 961, J.I. The various shades of meaning of Theord amendment may apply differently in different contexts. In the context 1N which that word, here's 1N Article 3681. It is neither ambiguous nor amorphous, but has a definite unproliwavananda. Tikalala, Chandrachud, J. 75. The proviso to Article 368 furnishes intrinsic evidence to show the U. And the word amendment is used in that article, not in a narrow and insular sense, but is intended to have the widest amplitude. The words such amendment obviously means amendment referred to in the main body of Article 368, and thus the article itself envisages that the amendment may take the form of change. Paragraph 7 of Part D of the 5th Schedule and Paragraph 21 of the 6th Schedule also furnish similar evidence of the meaning of the word amendment. Two things emerge from these provisions of the Schedules. First, the concept of amendment, as shown by Clause 1 of the Schedules, takes in addition, viewation, or repeal, and D, secondly, that an AMCND MCNTL, even by way of addition, variation, or repeal, would fall within the terms of Article 368. It is expressly accepted from the scope of that article, so that it may not fall within it which it otherwise would. Besides, The legislative history does not justify an inference that the word amendment was used in the draft Article 304 in order to curtail the scope of the amending power. It is important that 5 out of 11 judges in Goleknath took the view that the word amendment must be given a wide meaning. The leading majority did not consider that question on the ground that so far as fundamental rights were concerned, the question could be answered on a narrower basis. Thus, the word amendment in Article 368 has a dear and definite import, and it connotes a power of the widest amplitude to make additions, alterations, or variations. The power is so wide, Tliatit. Exprelly confers a power by Clause E of the proviso to